nutritional health to another area. It's completely a different area about intellectual property rights. The reason I've been asked to talk on this is because I was responsible for starting this intellectual property rights cell in our university way back in 2004. And since then, I have been the coordinator for this IPR cell. And from this cell, we have been filing patents of our university faculty. So that is the reason. So here, since we are teachers, we are also researchers, I'm going to share about what as researchers we need to know in order to regarding the intellectual property rights. So in research, IPR and ethics too are very important, apart from the study design, the research problem you select, etc. And we have to follow some research ethics, not steal or borrow somebody's data and present it as ours. And also, we should learn to protect our product. I mean, whatever which is the product of our intellect, we should learn how to protect that and also disseminate it among others, and if possible get some revenue out of the patents or copyrights, etc. So what should we know about IPR? Intellectual property means it's your own intelligence. It is your product of your property of your intellect. It might be artistic or literary work, or it can be a design or a symbol you have created. You could have created a product, a new drug, etc. And IPR is governed by World Intellectual Property Organization, the World Intellect. Okay, so WIPO harmonizes the global policy around the world. As a researcher, there are several published work to create a new thesis or to support our findings. And at the same time, we must not infringe the copyright of the owner or author of the published work by falsely claiming the figures and data is ours. Okay, so what is intellectual property? Intellectual property cannot be defined as in one perspective. It can be industrial property, it can be copyright, especially for people who come from the literary works, films, music, artistic work, architectural design, etc. So for this, copyright can be obtained. And we also often hear that, maker of one film might file a case against another who, without obtaining any copyright rights, another person will make another film, I mean, using the same story and everything. So basically, it is a creation of the mind, like invention, literary work, or artistic symbol, name, image, etc. And from the industry perspective, today we know the trademarks are so well known, and we know the Puma, the Nike, and various trademarks. We can, without even showing the name of that, just see the trademark, we can identify, and we'll say that this is of this car, of that vehicle. And there are industrial designs, and also today geographical indications, GIS, also is being awarded. Okay, so what are patents? These are the various types of IPR. Patent, it gives a protection to your invention. If you have created some invention, you can hold the right over it, and you will be the exclusive owner, and you can share that by selling it to others. That is by getting a royalty. So that is how there can be revenue generation. And copyright is it gives protection for expression of literary or artistic work. Trademarks, as I said, distinctive sign, design, and even database, right? Nowadays in this IT world, in this IT era, database right also is possible as one of the type of IPR. So how do we decide whether to publish or patent? Now, generally, as faculty, as teachers, we know that publication is very important for teachers. Maybe for from the career perspective, And also, apart from that, you may be interested to publish your work so that it is known to everyone. So, we publish it as abstracts or as a thesis, and then we attend various conferences, and we put up posters and all. So these are all various ways of showing our data or our invention. But along with that, by disclosing everything, we cannot file a patent. So disclosures that it can affect patenting are already publishing it in a journal before filing a patent, or already publishing the entire thesis, or putting it up in the internet, etc. So in India and US, a patent will not be granted for an idea that has already been published. So patents cannot be given for abstract ideas. And in Europe, you can see a researcher who has already disclosed his or her invention publicly loses the right to file a patent immediately. If you have already shared that whole thing in a public gathering, you are not allowed to file a patent. So these are some rules and regulations in various countries. So what are the advantages of collaborative research? Today we are collaborating with many organizations or institutions and all, because getting input, getting facility also will enhance the your research study or your research. So this has various advantages. It can result in higher quality of results, access to funding, learning new skills, etc. So these are the various advantages. And what is the take on collaborative research? That is, if more than two or three individuals are involved in the research, it can impact international research collaboration. That is, between Japan, an institute in Japan and an institute in India can collaborate. They can take national differences into account when planning global collaboration. This is very important because some countries have got very strict rules. Like if the major contribution is from their scientists or their faculty, then the share remains with them. So any other person from other countries cannot be a participant in filing a patent. So we have to be very careful about this. What are the differences, national differences? And as I said, in Europe, there are different options. In UK, it is different. In US, it is different. So basically, an ideal collaboration will provide everyone involved with the maximum ownership of patent rights. So we can also approach any company to file patents. We cannot do it on our own. So what is it we need to know at the start? It's very important that you have everything on a written agreement with the institution, and IP issues must be clarified in writing before research starts. That is when you are doing collaborative research. Who will own the intellectual property? If it is funded by the Indian Institute, then the IP ownership will remain with the institute which has provided the funding, either the institution, the funding agency, or the researcher. So this has to be clarified, and it should be very clear before we take up the collaborative research. And you discuss the invention in public, then it becomes a public disclosure, and you cannot file any patent. And clarity is important to be sought before initiation of the research. So why is intellectual property important? Why is it important to protect your intellect? Now, academic institutions have to adapt IPR because it is in academic institutes only. A lot of research is happening. So much, not only in science, even in social sciences also. Many theories may be proposed, copyrights may be developed, or they may develop some kind of algorithm, or maybe problem solving device. They might come up, mathematicians or computer scientists may come up with some kind of a software, so that people will not use it unauthorized. We need protection, and it will also generate revenue, give us fame and name also. So research can become public, and it can become a valuable resource. Ideas can be protected from exploitation by others. So these are the reasons why intellect has to be protected. So what are the benefits? we can advance research, we can take the research to an advancing level. And successful collaboration between academics, industry, and government is very essential in order to promote something which is be of use to the public. We can, make it available to everyone by following a proper route, and it provides legal certainty. And we can develop kind of, I mean, we can commercialize and generate some revenue from that also. So these are the benefits of IPR. In this PPT, in this slide, I have shown the relation between invention, patent rights, and economic development. Certainly, any institute having more patents, and of course, and if in case these patents have been purchased by big companies or anybody who's going to put it into use, then it can be a source of revenue generation for that institute. Okay, so at the same time, we must also have some protection for our intellect, and patent protection leads to development, manufacture, and then marketing. And by, I mean, if that product or invention is marketed more, it can lead to more economy. And by generating the money, this can give more funds to the researcher to conduct more research. So this is the relation between these aspects, that is invention, patent rights, and economic development. So to continue with the benefits of IPR, it leads to creation of public-private partnership, and encourages innovation. If your work is recognized, you feel motivated and you will conduct more research. You can get some reward for your creative effort, and you can also see to it that you can ensure compliance with applicable national laws and regulations, so that nobody will infringe and nobody will misuse your data or your invention. So as a researcher, we should know that whatever invention or copyright, whatever it is, how you can protect it. It should be under scrutiny until you file. That is, it should not be made public or share the data with even your own colleague. Be aware of your IPR and think about why you want an IP. I mean, just because it's not for claiming that I have got patents, you are going to file a patent. If you think it is really of use to be adopted by any industry or anybody, and it will further lead to some generation of revenue for yourself, and also ultimately that particular invention will be useful for the common man or for a target population. So everything should be recorded. We must start noting down all our data properly, and we should also follow ethics in research. As I said, it should not be fabricated data, and there must not be any bias, and for which high integrity in research is needed. And at the same time, it should be maintained confidentially. These are some of the ethical principles, and we should be able to protect legally also our data, so that nobody will infringe upon it or steal our data or lay a false claim over it. So, what is plagiarism in this context? I'm sure all of you are aware of it. It is an act of stealing somebody's work or stealing somebody's idea or work data. And that is definitely serious misconduct. Whenever we quote somebody's data, or anybody's research study, we have to cite the original work. I think all of you are highly aware of these. Like we cite the references. This is one example I can give. There are different types of plagiarisms which are generally categorized as direct plagiarism. Directly we copy somebody's work without changing anything, without giving due credit, or accidentally we may do it, or we fail to give credit, or it might be auto plagiarism or mosaic plagiarism. So this is how there are 4 different types of plagiarism. Normally, students have a tendency to complete their work fast. They may do it deliberately or they may do it accidentally. Okay, so now we will understand what is patentable and what is not patentable. Okay, machines, apparatus, or other articles are patentable. Even a pen has been patented. The method of for creating a cell phone is patented. So that you know why Nokia has it's this one concept is patented, whereas Apple has it patented. Okay, then the art and the process or the method of manufacture can be patented, and substances which are produced by manufacture, that is, for example, any chemical, how do you prepare that? That method can be patented. Method of testing a manufacture can be patented, and method of treating a plant can also be patented. Whereas what is
Process
not
patenting.
patentable? Hello?
Process patenting, madam. That.
Yes, yes. So what is not patentable is diagnostic, therapeutic, and surgical procedures, because we know that if surgical procedures were patented, then doctors will have to obtain permission from the original person who has devised that procedure, and it will not be a life-saving procedure. So therefore, diagnostic methods, therapeutic methods, and surgical methods are not patentable. Then plants, animals, and biological processes, except microorganisms, they are not patentable. And a method of agriculture or horticulture also, because agriculture methods have to be known to all farmers or cultivators. Atomic energy is non-patentable, and our India's traditional knowledge is also non-patentable. And just a scientific principle or an abstract theory, you cannot say that I have a wonderful idea. That cannot be patentable. And new property or new use, some old, the existing substance, another use of it, if you are proposing, that cannot be patented. Okay, so far in India, what all things have been patented in general? Neem, turmeric, apart from the scientific work, I'm just telling you, neem and turmeric, basmati, methi, jute, BT cotton, cow's urine, wheat, and diabetes, especially some work on diabetes has been patented. So there are, acts which protect the rights of individuals or inventors. We have Indian Patent and Design Act, which was created as early as in 1911. And from then, it has undergone a lot of modifications and improvisations. You can see that we have Patent Act in 1970, Repealing and Amending Act, so on and so forth. And we also have the Biodiversity Act, framed in 2002. All these acts are put forth in order to protect the rights of the inventor or the discoverer or the scientist, for that matter. So in India, let us try and understand what is the status of IPR in India. We have several agencies, like government agencies, like TIFAC, that is Technology Information Forecasting and Assessment Council, and BPFC, and NRDC, National Research and Development Corporation. There's an office in Bangalore, and you have the National Intellectual Property Right Facilitation Center. So we can approach these in order to understand what goes into the filing of a patent. Now, generally, the terms of patent is 20 years for general type of patents. And for food, medicine, and drug patents, it is 5 years from the date of sealing and 7 years from the date of patent. So, because after 7 years, there might be an improvement in that, there might be a different, patent filed on on a similar topic. That is why the validity for patents on food, medicine, and drugs is 7 years from the date of patent. Whereas for general patents, it is 20 years. Those rights, I mean, IPR is governed in India, though I showed earlier so many ones. What are are actually active and which are used in India are Trademarks Act, Patent Act, and Design Act, and GIS, and Semiconductor Integrated Circuits Layout Design Act. This is for the electronic and other good electrical goods. And there is also an act for protecting the plant varieties and farmers' right act. And we also have the Information Technology Act. So in India, who files, I mean, which is the central office? You have the Office of the Controller of the Patents, Designs, and Trademarks. The head office, is in Calcutta. We have got different branches. You have in Chennai, you have in Mumbai, you have in Calcutta, you have in Delhi. So these are all the various offices. And the IPR in India is mostly for patents, trademarks, trade secrets also, and as I said earlier, geographical indication, utility model or designing, plant breeders also, and copyright for literary art and work, etc. We have an institute called as Rajiv Gandhi National Institute of IPM, situated in Nagpur, which offers training for prospective patent filers, because patent filing, though, is not everybody's cup of tea. You have to get specific training to be trained to as a patent filer. Okay, so the acts are governing to patents, designs, trademark, and geographical indications. They are all different. The rules are also different, and there are manuals available. There are guidelines, and if anybody is interested, you can access this website, which gives about the IP India governance in India. And this organization will conduct online webinars, online workshops, online one day programs, etc. But they also offer physical training at this Rajiv Gandhi National Institute. That is, the training will be for a fortnight or sometimes even months, because then you will get a certification. You will get a certificate that you are a patent filer. So you have to know all the legalities and everything in patent filing. And in Mysore, as I said, Mysore University, we started this cell in 2004. And since then, we have been conducting a lot of awareness programs, workshops, sensitizing committee members. You know, if you have to serve in the IPR committee, you should be aware of what is required. So for which we have taken a lot of effort in organizing awareness programs for our research scholars, for our teachers. We have been doing it, and even the committee members are being sensitized from time to time. And we are telling them and encouraging them to take up research. And also, if whatever research they have come up with before publishing a paper, that if you find that it is patentable, then to submit the application for filing a patent. And I'm very happy to say that the previous Vice Chancellor, Professor Hemant Kumar, supported IPR a lot by giving some budget allocation. And what we do is to see whether this filing of patent also incurs a lot of cost. So whether you are filing a patent in India or international is not everywhere globally possible. You have to choose the country where you want to file. Like for example, is it France, or in general Europe or US? The fees for all this is different. So what we do before we undertake all this, and then finally you get a rejection from the patent office that this is already a patent on this topic is already available in that country, and then we end up losing our money also. So what we do is we get to screen the invention proposals by subject experts, because in physics or in electronics, or I think there are subjects experts are there, they will be aware of it. So this one, in confidentiality, in maintaining confidentiality, we submit it to them, and they screen it and tell us, yes, there is something worth in it. And then we have filed an MOU with the patent agency, and they conduct the prior art search. And if they find that the matter or the work is suitable for patent, then we go ahead for filing the patent. Okay, so this was just about a very brief way of, I explained about what a researcher should know. I have one more aspect. Just a minute, please. Bear with me for a minute. See, this might be of interest for all of us. That is, not all are pursuing science. So, if you are in any of these areas, what all is patentable or what is not? We don't call patents for everything. I mean, the name is not patent for everything. Instead, if it is a work of art, like literary or drama work, so somebody will be the author of the work, or it will be a musical work composed by someone. It is an artistic work or a photograph or a cinematograph, a sound recording. All of them are one can have the ownership, or rather we call it as copyright. Normally, the author of the work will be the first owner, subject to some kind of exceptions. So, IP rights can be registered or unregistered. In case of patents, trademarks, and design rights, it has to be registered. In case of copyright and database rights and all, not necessary, it need not be registered. Now, when I even talked of trademarks, see, this is like the size of the bottle and how the word Coca-Cola is written, and the shape of the bottle, the logo type, the symbol, slogan. Below M, we know we are very familiar about this, slogan, I'm loving it. Okay, so this is very, very synonymous, and it is the right of this company. Nobody can misuse it. Like, there we find that there are always imitations. This M, which is synonymous with McDonald's, it may be written in a different shape, and the font size can be changed, and they might change the slogan. But in this case, what happens is the original owner of this trademark can file a case against those who have infringed and copied that their trademark. And as I said earlier, industrial property and copyrights and related rights, geographical indications are also acceptable. Layout designs of semiconductors, plant varieties, trademarks and service. These are all some examples of Kolhapuri chappal. That has also been, it has received a geographical indication. So there are even books and even plant varieties are related. These are all types of IPRs. So there are different types of patents. Ordinary patent, a patent, I mean, your own patent, you have improvised on the work and you can apply for an improvement or modification of the patent. A patent can be granted in respect of convention applications to be made within 1 year from the date of application. So as somebody pointed out, patents are different type. You have product patent, then you have process patent. So by filing patents, we get some protection, and we can prevent from exploitation. We have the exclusive right to legal action against infringement, and you can claim damage for, if you find that somebody has started producing that particular product without taking any permission from you, then you can claim damage for the infringement. So there are ways to secure your patent. That is the creation, the protection, the utilization, the enforcement, and you can have you will hold the exclusive right, and you have the right to assign it to X, Y, or Z based on some kind of a mutual agreement, and they purchase your patent by paying some royalty. Okay, so you need a patent if you have invented a product. You believe someone else could sell the product by copying your inventions. So then you have to protect your invention. So patent application should have many components, like, for example, complete description. You cannot withhold any information. You have to reveal everything to the patent office. Then if it is technology or a machine or whatever, the drawing of the invention should be disclosed, and you have to complete the form declaration for patent application. I tell you, these are not easy. The terms which are used by patent officers are beyond our comprehension, because it's you and I, we are scientists, we are researchers. So it will be written in a very legal language. So we will always need the help of a trained patent officer, patent filer, to do that. And they will require a notarized statement. Then, as I said, there is a filing fee for to be paid to the patent and trademark office. So if you have to apply a patent for a patent, what are the steps or the stages? First is the disclosure document. Then that will give us a 2-year grace period for filing to complete the patent filing process. You will get either you can file for a provisional patent or you can file for a non-provisional patent. So provisional patent will protect our ideas while you are, discussing with the manufacturer or anyone who can be funding your study in future. So you can use the term patent pending on the invention if you have filed for a provisional patent. This will be valid for 12 months. Then you must file non-provisional application with the PTO, Patent and Trademark Office. And then we are able to use this term patent applied for, which will be valid for 2 years. So for 2 years, we are protected. That means nobody can infringe and you have the right to take legal action. Infringement, I'm sure all of you understand this. This is like, if some other person other than the patentee or his assignee has illegally infringed and used that, that substance or the process or the product without the permission. So then you have the right, the original patent holder, the patentee has the right to file for a case. So as I said, these are the various branches or types. What is a process patent? It is an application by an inventor or his assignee. It is, the process of patent, first you have to apply. It will be examined by examiners. As I explained earlier, in our university, we form a subject expert committee by inviting someone who is not related to the university. So they will examine the content and they'd say that yes, there is something in that which can be filed, then only we go ahead. Otherwise it will be a wasteful journey, taking up all the effort and then finally getting rejection from the patent office. So advertisement, then it will be, they will take care, they will advertise in the official gazette and they'll wait for a period until somebody opposes that we also have come up with this kind of a product. They will wait for some period, the patent office will wait for a period, and then in case within that period nobody opposes, then the patent is granted. Now the granting of patent can take more than 2 years and 3 years. So the journey from the application to the grant of patent can be long. We need to have a lot of patience. So as I said, 20 years for general types. For food, medicine and drug patents, it is 5 years from the date of sealing and 7 years from the date of patent. As I said earlier, I think I've already explained what is patentable and what is not patentable. These are the various ones. Now, for science people, I would just like to express a few things. Issues which are related to pharmaceuticals and biological material. This can be dealt at local level, national and international level. And of course, all these pharmaceuticals and biological materials have importance even at the national and international levels. We can patent inventions, we can patent biological materials, laboratory processes, process of extraction of some bioactive or a nutraceutical. Even pharmaceutical methods are also patentable. In all this, we should not forget that there is bioethics involved. There are ethical and legal aspects. So we should comply by all of them. The major issues what we are finding today in, especially the field of molecular biology and biotechnology is regarding the cloning, genetics, stem cell research, xenotransplantation, that is transplanting the organs from animal to human. These are some of the major issues which the field of medicine and biotechnology and molecular biology is facing, and about biodiagnostics and biotherapeutics for developing effective diagnostic kits. See, recently the entire world was affected with COVID. Now they had come up with kits to detect whether a person is infected with the coronavirus or not. And that was based on a PCR method, that is polymerase chain reaction method. if that was patented, if that method to diagnose whether the person has corona, he's affected by coronavirus or not, if that was patented, that diagnostic procedure would not be available to anyone to get himself tested. That's why I said diagnostics, therapeutics, and surgical procedures are not patentable, because these are all life-saving devices. So we have a lot of studies which have gone on to understand what is patentable and what is not patentable. There is one organization called Hastings Center, which focuses on patenting of essential drugs for conditions such as HIV and AIDS. Now, if just imagine if these drugs have been patented, then those who are affected by HIV or AIDS can never have access, and no drug company can manufacture it. So that is why some of these therapeutics are not patentable. And there is also one program called as LC research program. There is a research institute by name National Human Genome Research Institute, which manages the ethical, legal, and social implications, funds, and manages genetic research. This is a European organization. So, where biotechnology is concerned, there are a lot of research and applications happening with respect to agriculture and food, biomedical and tissue engineering, bioremediation, biotherapeutics, genomics, and stem cell. This is a repeat of what I mentioned earlier. Now, TIFAC is a unit of Department of Science and Technology. So they publish monthly bulletin on IPR. They keep track of patents. For example, if a research project is funded by DST or by DBT, we are obliged to file a patent through them only. We cannot supersede or avoid DST or DBT, or in that matter, even ICMR. So whichever agency has given us funds, we are obliged, are bound by rules which govern that particular agency, like ICMR or DBT, etc. So so far, TIFAC has facilitated more than 300 patents which are filed in India and abroad. Patent information centers have been established in 20 states, and they have all the data on CD-ROMs. They publish even monthly bulletin on IPR. So we have another organization, that is BPFC, as I mentioned earlier. This also has facilitated filing of patents. See, please remember, the number of patents filed might be 300, 400, but ultimately the number granted will be much lesser. So awareness creation is done by WIPO, and NLSIU also undertakes training of scientists. But the national organization is this Rajiv Gandhi Institute for Patent Filing and Research, which I said is situated in Nagpur. We have various patent offices in India. As I said, Kolkata has the head office, which deals with rest of India, patents coming from rest of India, other than Chennai, Delhi, and Mumbai. So the jurisdiction of Mumbai is restricted to Gujarat, Maharashtra. So if you are in Maharashtra, if you want to file a patent, you have to approach the Mumbai office. So if you are in UP, you have to approach the Delhi office. Or similarly, if you are in Pondicherry, Karnataka, you have to approach the Chennai office. So we from Mysore University, our patents go to the Chennai office through the patent filing agency. So this is a picture of that Rajiv Gandhi National Institute of Intellectual Property Management. We were deputed there, myself and my another colleague who is a committee member. We went and stayed there for quite a number of days, and got ourselves trained and to understand what are the nitty-gritty aspects of patent filing, because we are all teachers. We may know only the theoretical aspect. We may not know how it has to be conducted in order to create awareness among our fellow staff. So NRDC is another organization which is one of the leading technology transfer organization in India. Before we filed this, we had this MOU with this patent filing agency. We were filing our patents through NRDC. So they charge nominally. So it is always good if we don't have any organization through which you can go, NRDC will be the better choice. Now I am showcasing this in order to, as a motivator or as a this one to motivate us to undertake research, or the research what you have done to find out whether it is patentable or not. This Indian origin scientist has more US patents than Thomas Alva Edison himself. So he's one IIT, alumni of IIT Delhi, and he is now in US, and he has 1,299 US patents. So this only speaks of his intellect, how intelligent he is, and how he has protected his intellectual property in a country like US. So by having highest number of patents filed in USA, filed and granted in USA. So this is just an analysis, a figure showing.
Madam, can we interrupt,
Uh,
madam? Once again, madam.
yes.
ಮೇಡಮ್ ಈಗ ಸ್ಮಾಲ್ ಫಾರ್ಮರ್ಸ್ಗಳಿಗೆಲ್ಲ ಅಗ್ರಿಕಲ್ಚರಲ್ ಇಂಪ್ಲಿಮೆಂಟ್ಸ್ ಮಾಡ್ತಿರ್ತೀವಿ, ಚಿಕ್ಕ ಚಿಕ್ಕದು ಅವ್ರಿಗೆಲ್ಲ ಕೃಷಿ ಮಾಡೋದಕ್ಕೆ. ದಟ್ ವಿ ಕ್ಯಾನ್ ಕ್ಲೈಮ್ ಆಸ್ ಎ ಪೇಟೆಂಟ್.
Yeah, that is a device. You can patent that.
Yes, small implements
devices. But we must prove what is its usability, and there are a lot of things which go into it. Since we have not dealt with this kind, I don't have much information.
ಯಾಕೆಂದ್ರೆ ಮೇಡಮ್, ಹಳ್ಳಿ ಕಡೆಯಲ್ಲಿ ತುಂಬಾ ಮಕ್ಕಳು ಹೊಲದಲ್ಲಿ ಕೆಲಸ ಮಾಡುವಂತರು.
ಹೌದು ಅಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ಏನಾದ್ರೂ ಇನ್ವೆನ್ಷನ್ ಮಾಡಿ ಏನಾದ್ರೂ ಒಂದು you have come up with some kind of a device, or it can be a kind of an instrument which will minimize some labor, or it will maximize something. Athara enadru if you have, but you must support it with previous such kind of devices, and how this is a better one, and you must give some evidence that how proven how it is, how you have proven it.
Okay.
So the yardsticks for such devices are different. Probably you will have to consult somebody who is concerned in that area.
Okay.
I don't have much information on that because we have not processed anything. So the main what we have processed is all scientific information only, inventions and all. Okay.
Okay, thank you.
It is possible. You can. Okay. Can I move further?
Please, madam, please.
Yeah. So this is the whole process. It takes, we also have filed, my group has also filed patents. It takes at least 2 years. So we have to be patient. Okay. But we should not become a patient in this process. Identify the invention, you do the prior art. Normally what happens, we as teachers, we would not plan right from the beginning, before doing the research, before undertaking the study, that patent ಮಾಡಲೇಬೇಕು ಅಂತ ಮಾಡಲ್ಲ. ರಿಸರ್ಚ್ ಆಗೋಗಿರುತ್ತೆ, ಇವಾಗ ಪಬ್ಲಿಷ್ ಮಾಡೋದೇ ನೆಕ್ಸ್ಟ್ ನಮ್ಮ ಉದ್ದೇಶ. ಬಟ್ ಕೆಲವು ಸಲ ಏನಾಗುತ್ತೆ, ದೇರ್ ಇಸ್ ಸಮಥಿಂಗ್ ವಿಚ್ ಇಸ್ ಆಫ್ ಆಸ್ ಲಾಟ್ ಆಫ್ ಇಂಟೆಲೆಕ್ಚುಯಲ್ ವ್ಯಾಲ್ಯೂ. ಸೊ ವಿ ಕ್ಯಾನ್ ಜನರೇಟ್ ಸಮ್ ರೆವೆನ್ಯೂ ಅಂಡ್ ಪ್ರೊಟೆಕ್ಟ್ ಅವರ್ ಇಂಟೆಲೆಕ್ಟ್. ಆವಾಗ ನಾವು ಬಿಫೋರ್ ಪಬ್ಲಿಷಿಂಗ್ ವಿ ಕ್ಯಾನ್ ಗೋ ಅಪ್ಲೈ ಫಾರ್ ದಿಸ್ ಪೇಟೆಂಟ್, ಅಂಡ್ ದೆನ್ ಫೈಲ್ಡ್ ಫಾರ್ ಅ ಪೇಟೆಂಟ್ ಅಂತ ಹಾಕೊಂಡ್ರೆ ಅವಾಗ ನಮಗೆ ಪ್ರೊಟೆಕ್ಷನ್ ಸಿಗತ್ತೆ. ಸೊ ಇಟ್ ಟೇಕ್ಸ್ ಅ ಲಾಟ್ ಆಫ್ ಟೈಮ್. ದಿಸ್ ಇಸ್ ಅ ಜರ್ನಿ. ಫಾರ್ ಅಸರ್ಟನಿಂಗ್ ಓನರ್ಶಿಪ್ ನಮ್ಗೆ ಎಷ್ಟೊಂದು ಎನ್ಕ್ವೈರಿ ಬರುತ್ತೆ ಅವರಿಂದ. Like who is the first owner, whose idea was this, who contributed. If there are 4-5 people, then we have to justify the contribution of all these 4-5 people in that. Okay. So process, patent process, as I said, we should not publish it initially, but publication andre your bhashenalli publication is, you have to give a description about it to the patent office. Then that will be examined and we will get the response. And if there is any amendment, we have to amend that and give it to them. Then they will comply by it, and only it takes a lot. I mean, after compliance only the patent will be granted. And there is also a provision for renewal of the patent. So here is one example I'm just sharing. We all know about the basmati rice. We love preparations made out of basmati rice. Actually, it is the origin of Pakistan and India. Indian varieties are these many, like which are traditionally cultivated in Rajasthan. you have various varieties like Basmati 198, 217, etc. And this is how you identify the Basmati rice. And what happened was the patent office at US, they had filed for it, and they said it is grown outside India. India objected to it because it is, hello? India is one of the major exporter, and this is one thing at the national level which India faced. I'm just trying to explain to you all about it. So India objected to this, and they said India is one of the major exporter, and they cannot grant a patent for this. Since Basmati rice is traditionally grown in India and Pakistan, it was appointed granting patent to this particular organization, Rice Tech. It violated geographical indication. That means it is a property of India, rather because it is cultivated traditionally from centuries. So the claim was aroma has been developed by Rice Tech was misleading. This was the claim. And it took back 15 claims out of the 20 claims. And then they also withdrew. Finally, we won the case. India won the case. And they withdrew its claim on the name Basmati. So they were not granted this permission. And turmeric is yet one more. A US patent was awarded to University of Mississippi in 1995, and they said it is used in wound healing. But we all know that from centuries, turmeric is used in Indian medicine to treat for wound healing. So for all this, one person, one scientist by name Mashelkar, who was the Director General of CSIR, was very responsible for, creating awareness among IP in the Indian scientists. So he has done a lot of work, and they woke up to this turmeric thing. Here I told, no, University of Mississippi had filed one case, so they took note. CSIR took note of this claim, and then they argued that turmeric has been used for thousands of years in India, and it is not a novel invention. So their claim was supported by all the evidence of traditional knowledge, documents from India. They were all presented. So it was granted, though it was granted in 1995, the CSIR requested for a re-examination in 1996. So first the office action rejecting all the patent claims happened in 1997, and the re-examination happened in 98, and the proceedings were in favor of CSIR. So this is the second case where again India, had we kept quiet, we would have again lost to this, saying that turmeric has wound healing property. That would have been their claim. Although it is well known that turmeric is used in Indian homes for wound healing since n number of years. So now CSIR, after these cases, I think scientists are more alert. So these are some of the figures. I could get this, how many patents have been filed. Actually now from 2017 onwards, we can see that there is an increasing trend in filing patents. So although so many are filed, not all will be granted. You can see that only few will be granted. And you can even file in China or Australia or Germany, but their rules will be different to verify whether your content is patentable or not. So to end with, I would say that definitely IP rights are yardstick of techno-economic growth. That is, the more patents we have, granted patents, that means we have higher intellect, and people can approach us to buy that patent, that process or product for their for commercial use, and that will lead to revenue generation. Thank you. This is a different topic I dealt.
Madam, right now we have this GIS mark on the geo tag ಕೊಡುವಂತ ಒಂದು ಪ್ರಾಕ್ಟೀಸ್ ಅಲ್ಲಿ ಇದೆ. ಸೊ ಇಸ್ ಇಟ್ ಆಸ್ ಲೈಕ್ ದ ಸೇಮ್ ಥಿಂಗ್ ವಾಟ್ ವಿ ಹ್ಯಾವ್ ಲೈಕ್ ಅನ್ ಪೇಟೆಂಟ್? ಬಿಕಾಸ್ ನಮ್ಮ ಈಗಿನ ನಾನು ಇಲ್ಲಿ ಪ್ರೆಸೆಂಟ್ಲಿ ವರ್ಕಿಂಗ್ ಅಟ್ ಸೆಂಟ್ರಲ್ ಟ್ರೈಬಲ್ ಯೂನಿವರ್ಸಿಟಿ ಆಫ್ ಆಂಧ್ರ ಪ್ರದೇಶ್ ನಲ್ಲಿ ನಾನು ವರ್ಕ್ ಮಾಡ್ತಾ ಇರೋದು ಆಸ್ ಅಸಿಸ್ಟೆಂಟ್ ಪ್ರೊಫೆಸರ್ ಆಗಿ. ನನ್ನ ರೀಸೆಂಟ್ ಆಗಿ ನನ್ನ ಇಬ್ಬರು ಕಲೀಗ್ಸ್ಗೆ ಫ್ರಮ್ ಕೆಮಿಸ್ಟ್ರಿ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ದೇ ಗಾಟ್ ದೇರ್ ಪೇಟೆಂಟ್. ಸೊ ಈಗ ನಾವು ಜಿಯೋ ಟ್ಯಾಗ್ ಅನ್ನ ನಾವು ಹೇಳುವಂತದ್ದು ಅಥವಾ ನಮ್ಮ ಈ IPR ರಿಲೇಟೆಡ್ ಈಗ ನೀವು ಪೇಟೆಂಟ್ ಅನ್ನ ಹೇಳಿದ್ರಲ್ಲ, ಅದೇನಾದ್ರು ಡಿಫರ್ ಆಗುತ್ತಾ?
ಇಲ್ಲ, ಸಿ ಪೇಟೆಂಟ್ ಇಸ್ ಡಿಫ್ರೆಂಟ್ ಫಾರ್ ಅ ಪ್ರಾಡಕ್ಟ್ ಆರ್ ಪ್ರಾಸೆಸ್ಗೆ ನಿಮ್ಗೆ ಪೇಟೆಂಟ್ ಬರೋದು, ವಿಚ್ ಡಸಂಟ್ ಕಮ್ ಅಂಡರ್ ದಿಸ್ ಆಂಬಿಟ್. ಫಾರ್ ದಟ್ ಯು ಗೆಟ್ ಅ ಜಿಯೋ ಟ್ಯಾಗ್, ಜಾಗ್ರಫಿಕ್ ಇನ್ಫಾರ್ಮೇಶನ್ ಆ ತರ ಬರುತ್ತೆ ನಿಮಗೆ. ಸಿ ಇವಾಗ ನಾನು ಹೇಳಿಲ್ವಾ ಕೊಲ್ಹಾಪುರಿ ಚಪ್ಪಲ್, ದಟ್ ಚಪ್ಪಲ್ ಈಸ್ ಸ್ಪೆಸಿಫಿಕ್ ಟು ದಿ ಏರಿಯಾ ಕೊಲ್ಹಾಪುರ್. ಆರ್ ಈವನ್ ಯಾವ್ದೋ ಸೀರೆಗೂ ಬಂದಿದೆ ಇವಾಗ ಜಿಯೋ ಟ್ಯಾಗ್, ಈ ತರ GIS ಇಳಕಲ್, yes like that, you know. So for the product or whatever it is which is traditionally prepared and made in that area, so it has to be commercialized like that only. We cannot say these sarees are done in any other part of the country. So patent and this, only the term is different, but it is again protecting your it's not in the GIS or in the geo information tag. We don't get, it is not a product of our intellect, but it is a contribution from many. That ilkal sari now is traditional of those people, or that kolhapuri chappal, that is a product which people from that area have contributed in making of it from several years. Yes.
So what is the limitation period of patent in India, madam?
Illa general patents ಗೆ